You're listening to the Hidden Killers podcast with Tony Brueski,
featuring author, guest, and criminal defense lawyer Lori Hellis.
Judge in the Bryan Kohberger case saying, yeah, those arguments about the grand jury instructions, they're not enough to grant you out of this, and you can't just go home. I'm sorry. But you can take a look at some of those genealogy pieces of evidence that have been looked at by the prosecution thus far. Joining us to discuss, Lori Hellis, author, defense attorney. Let's talk about some of that genealogy, DNA evidence, some of the stuff that linked him to the crime, eventually to his parents' house in Pennsylvania, and obviously then into making an arrest. Shouldn't the defense have access to this already? Is this a real faux pas, weird thing that they're asking for this, or that they shouldn't have access to it already?
Hi, Tony. Thanks for having me.
Sure.
Well, they did have the DNA evidence. The larger question is one that's sort of uncharted territory, and that's the issue of the genetic genealogy. So it's sort of wanting to know how the sausage is made, if you will.
Okay.
Because the whole field of genetic genealogy is really in its infancy, and understanding how those family trees are put together and how those connections are made within the databases is really what the defense is looking for. Mm-hmm. They want to know how the prosecution, how the state made the connection between Kohberger and we think his father's DNA that was found in the trash. They want to know how that happened. And there is a valid reason for wanting to have that information.
Sure.
Many of the commercial DNA databases have an agreement with their users that they will not turn that information over to law enforcement. And most of the law enforcement policies preclude them from using those commercial databases that are contractually obligated to their users. Mm-hmm. However, it's kind of an honor system. So it's a little bit hard. Sorry, no. Barking dogs.
That's fine.
It's a little bit difficult for them to be certain that those databases weren't misused, mm-hmm. unless they get the raw data of where these database connections were made. And so I think that more and more we're going to see judges saying, yeah, you got to provide them with the information about how the sausage is made. Mm-hmm. You've got to give them the worksheets and the screenshots that show where you got that connective information. It's not enough to say it's no different than a tip, and we went and then generated our own data based on a tip. Mm-hmm. So I can see that. I expected that the judge was going to require that the prosecution provide that information to the defense.
Sure.
Just based on the experts that testified in the original hearing. Mm-hmm. Yeah. So I think it is an area of the law where we're seeing some developing policy, if not some appellate law being made.
So what's the goal here for the defense of Kohberger by bringing this up? Are they trying to go down a route of saying, look, you obtained this information in an illegal way or in a way that was not agreed to by the parties who submitted their DNA, thus it's not applicable or cannot be used in court against Kohberger?
Absolutely. Okay. Absolutely. They're likening it to an illegal search.
Okay.
And saying any information that comes from the fruit of the poisonous tree, as we call it, mm-hmm. Any information that's turned up as a result of that illegal search then becomes inadmissible as well. So they can get rid of that whole line of evidence mm-hmm. having to do with DNA.
even though factually, I mean, we're talking about the rules basically of how it was obtained, not necessarily the factuality of the evidence itself once you are examining it. And if the evidence itself does not lie and it shows that there is this link here, there's that link there, regardless of if it was obtained incorrectly or not, correct?
Well, sure, but that's why we have a Fourth Amendment, because there are procedures and acceptable ways of obtaining information. And if information is obtained illegally, it can't be admitted in court.
Sure.
That's what keeps you and I safe from having our property or our private information searched or seized. And the court's been very clear about what the limits are. So we know that if you put your garbage out on the street corner, which is where they got the DNA, you have no expectation of privacy in your garbage on your sidewalk.
Sure.
Or in your driveway. But if you have put your DNA in a database where the company agrees that they will not share that information with law enforcement, you do have an expectation of privacy in that data, because your agreement with that third party is that will not be shared with law enforcement. If law enforcement sneaks in the back door and gets that information by masquerading as a citizen, then that information has been illegally obtained in a situation where you had an expectation that information was going to be kept private. So I think that's the difference.
What are they basically asserting here that took place, that somehow they got into this database masquerading as a citizen, or in some way that was not ethical or legal? I mean, what do we know about that? What has the prosecution said about how they obtained that information in terms of any violating anything?
The prosecution claims that they didn't violate any Fourth Amendment rights, that they obtained the information legally. But the defense knows that there have been other cases where law enforcement has obtained that information illegally. So I guess what the defense is saying is we don't know whether that information was obtained legally. If it was, no harm, no foul.
Sure.
If it was, then giving us the information shouldn't be a problem. If it wasn't obtained legally, then we have the right to know that so that we can file the appropriate motions and keep that information out.
Sure.
So they are really, I think it's clear that they are entitled to the information.
Sure, without a doubt. Let's say that there is something here, that it was obtained improperly and that they do have to throw this out and it's not going to be admissible. How much do you think that affects the case against Kohberger, if at all?
Well, I think that it's damaging to the case, but I don't think that it's fatal, because they did connect Kohberger to the scene through the car, through the Hyundai Elantra, and they were able to follow him. And I think they would make an argument that even if the genealogy connection gets thrown out, that they still had probable cause to get a warrant to get his trash. And they still were able, once he was arrested, they still had probable cause to arrest him. And once he was arrested, then they compared his DNA to the DNA they found in the garbage. I think they can probably do an end run and perhaps get that information in anyway. But I don't, it certainly doesn't, it weakens their case somewhat.
Yeah. Is it essentially saying that, look, all these dominoes started falling because of this one over here, but had this one not fallen, none of these would have fallen over here. So all these that fell have to be put back up, basically, because this wouldn't have occurred to begin with. And is that a strong enough argument? Is a judge going to go down that, like you just said, there were all these other reasons and probable cause to arrest, in which you could get that information many other ways. This just happens to be the way that they did it.
Sure, but I think there were other indications that there was probable cause that could underpin his arrest. So his arrest isn't illegal. The search into his parents' home isn't necessarily illegal because they had probable cause knowing that the car was there and that he was the owner of the car. So I think that certainly the prosecution wants to put their strongest argument forward, and their strongest argument may be the genetic genealogy. But I don't think that it's fatal to their case. I think they can still go forward and prosecute him.
All the more reason you need to play by the rules when you're doing these things, because you don't want to end up in situations like this where you have a super strong case and you may have someone who's very guilty, but sometimes they're able to get out on those technicalities. Very interesting.
Absolutely. And it may be, I think we're seeing that in a couple of other cases around the country right now having to do with some misconduct, either on the part of the prosecutors or on the part of law enforcement. And we're seeing that. And I don't honestly know whether we're seeing more of it or it's just becoming more obvious because these trials are becoming so much more public.
Yeah.
But it really does sort of suggest that sunlight really is a true disinfectant, and that the sunlight of public viewing and the public being aware of what's going on in these cases really does hold the government to their obligation to play fair. And it's difficult because the government has nearly unlimited resources. And the little guy, the defendant, doesn't necessarily. So, yeah, I think it does point out that we all need to observe the rules and play fair because that's what we would want if we were on trial.
Very true.
Protecting Bryan Kohberger's rights when he's potentially committed this horrible crime seems a little distasteful to people, but we have to remember that protecting his rights protects yours and mine if we're arrested and have to answer charges.
Sick of the ads?
We are too.
Start listening with no commercials now and get access to all of our episodes in advance of everyone else.
Become a True Crime Today Premium Plus subscriber on Apple Podcasts.
Search True Crime Today Premium Plus on Apple Podcasts or go to our podcast page and sign up now.
True Crime Today Premium Plus.
Sign up now.